Three major lawsuits to throw out Trump's devastating H-1B regulations. Welcome to Voice of Immigration. I'm your host, John Veely, CEO of Online Visas, the intelligent immigration platform. Under the request of the Trump administration, in presidential proclamations issued this summer during the pandemic, both the Department of Labor and the Department of Homeland Security issued new H-1B rules and regulations that immediately jeopardized hundreds of thousands of foreign nationals in our country that use the H-1B visa. As a result, 3 federal lawsuits have been filed in 3 different courts. One complaint was filed by the U.S. Chamber of Commerce, the National Association of Manufacturers, the Presidential Alliance on Higher Ed and Immigration, and other organizations, including major universities like Stanford and Cornell in the Northern District of California. The Chamber plaintiffs disputed the good cause exception to the requirement of providing an opportunity for notice and comment from stakeholders under the Administrative Procedures Act, the APA. What that means is that typically for a regulation to go into effect, notice and comment has to be out there so people that will be impacted, like all of the U.S. employers that hire H-1Bs and those that want to get them, have an opportunity to weigh in and they can use this data to come up with fair regulations. That didn't happen here. An interim final rule was issued instead. So the government used a rationale, as stated in the regulation, that there was a significant jump in unemployment due to COVID-19, looking at the dates from August 2019 to August 2020, in 2 different industry sectors where a large number of H-1B workers were employed. But the unemployment for those sectors include all jobs in the companies that constitute those sectors, so janitors, receptionists, and all the others. Only roughly 10% of the jobs in those sectors are in occupations similar to those occupied by the highly skilled university graduates that the H-1B professions entail. The complaint further cites the National Foundation for American Data, the NFAP, which states the unemployment rate in the computer occupations was only 3.5% in September 2020 and did not change significantly from when the pandemic hit in February, when the rate was 3%. Under the complaint filed by IT Serve Alliance on behalf of other prevalent tech companies against the Department of Labor in the Federal District of New Jersey, that was filed for dramatically altering the manner in which calculating prevailing wage rates for the H-1B program. Prevailing wages are the minimum wage that a company must pay an H-1B worker for the county and state where the job is going to be performed. The Department of Labor hiked that from a 17% to a 34% rate in the first level. What that meant is almost double the wages that you would have to pay for these jobs, making entry-level jobs in this profession unhireable. That jacked up over 100,000 to 200,000 in some professions across the board and really made it an unworkable thing. So that's what this case is about. So the plaintiffs brought this action challenging the Department of Labor's decision to set dramatically higher rates without following the notice and comment rulemaking procedures required under the Administrative Procedures Act. What they did on that one is place it immediately into play, where that is going on right now, whereas the H-1B rule under USCIS and Homeland Security doesn't go into effect for 60 days. So this issue is already causing lots of employers, U.S. companies, not to be able to use the H-1B for their employees. Plaintiffs also challenge the agency new wage rates as violation of the Immigration and Nationality Act as amended, because the new wage rates are set under a novel standard that conflicts with the governing statutory criteria. The Department of Labor's new wage rule is also arbitrary and capricious because the agency relied on outdated, incorrect, or limited empirical data, failed to consider readily available relevant data and empirical studies, and engaged in reasoning that conflicts with the basic economic theory. Another complaint was filed by Purdue University with several other universities and companies like Information Tech Industry Council against the DOL's H-1B rule. It was filed in the Federal District Court in the District of Columbia. The lawsuit, spearheaded by the American Immigration Lawyers Association, also known as AILA, filed a motion for preliminary injunction requesting that, based on the foregoing, the court should enter a preliminary injunction enjoining the defendants and the Department of Labor from implementing, applying, or enforcing the interim final rule or any of the prevailing wage methodologies or prevailing wage rates under the interim final rule in its entirety. The lawsuit references the detrimental reliance U.S. employers and foreign national beneficiaries have, as well as bypassing this standard review process. According to the Purdue complaint, under Executive Order 12866, any rulemaking that is likely to result in a rule that may have an annual effect on the economy of $100 million or more, or adversely affect in a material way the economy, a sector of the economy, productivity, competition, jobs, the environment, public health or safety, or state, local, or tribal governments or communities requires further review. The rules being implemented by the Department of Homeland Security and the Department of Labor undermine highly skilled immigration in the United States and a company's ability to retain and recruit the very best talent, says the U.S. Chamber CEO Thomas J. Donahue. He represents a lot of people. There's a lot of people and companies represented by these three lawsuits going on in three different courts. Hopefully for immigration and our economy, they, like the other lawsuits, will throw out these arbitrary and capricious rules that the Trump administration has attacked on merit-based immigration. I'm John Veely, CEO of Online Visas, where we deliver dreams.